After discussing international framework, now we will discuss national framework. And the first category under national framework is Environment Protection Act 1986. There is an urgent need for the enactment of a general legislation on environment protection which inter alia should able coordinate of activities of the various regulatory agencies. Creation of an authority or authorities which educate power for environmental protection, regulation of discharge of environmental pollutant and handling of hazardous substances. Speedy response in the event of accident threatening environment and deterrent punishment to those who endanger human environment safety and health. We all aware that there is a catena of statutory law in India to deal with the environment issues, but this is the general umbrella that cover each and every aspect related with the environment. Next is Manufacture, Storage and Import of Hazardous Chemical Rule 1989 and the Manufacture, Storage and Import of Hazardous Chemical Amendment Rule 1994 and 2000. These rule directs that an occupier shall not undertake any industrial activity to which this rule applies, unless he has prepared a safety report on that industrial activity containing the information specified in Schedule 8 and has sent a copy to the report to the concerned authority at least 90 days before commencing that activity. To ensure the safety, it is also provided that after the commencement of the manufacture, storage and import of hazardous chemical amendment rule, the occupier of both the new and existing industrial activities shall carry out an independent safety audit of the respective industrial activity once a year with the help of an expert that should not be associated with such industrial activity, and a copy of the auditor report along with his comments should be forwarded to the concerned authority within 30 days after the completion of such audit. Modification to the industrial activity to which that safety report relate that could materially affect the particulars in that report shall not be made by the occupier unless he has made a further report to take account of those modifications and has sent a copy of that report to the concerned authority at least 90 days before making these modifications. He is bound to give the information, and information should be given to the person liable to be affected by a major accident. The occupier, before that activity is commenced, shall take appropriate step to inform person outside the site either directly or through direct emergency authority who are likely to be in an area which may be affected by major accident about the nature of the major accident hazard and the safety measures and the do's and don'ts which should be adopted in the event of major accident. Any person responsible for importing hazardous chemical in India shall provide at least 30 days before the date of import to the concerned authority as identified in column 2 of Schedule 5 the information pertaining to the name and address of the person receiving the consignment in India, the port of entry in India, mode of transport from the exporting country in India, the quantity of chemical being imported, and complete product safety information. Next, we are going to discuss Biomedical Waste Management Rule 2016. Biomedical Waste Management and Handling Rule 1998, reviewed in 2016, regulate the manner of disposal of biomedical waste and provide a detailed framework for the mechanism and processes to be followed for the effective disposal. These rules shall apply to all persons who generate, collect, receive, store, transport, treat, dispose or handle biomedical waste in any form, including hospital, nursing homes, clinic, dispensaries, veterinary institutions, animal houses, pathological laboratories, blood bank, Ayush hospitals, clinic establishment, research or educational institution, health camps, medical or surgical camps, vaccination camp, blood donation camp, first aid room of school, forensic laboratories and research lab. After discussing the international and national framework, now we will discuss the role of judiciary to ensure the dignified existence. In Vellore Citizen Welfare Forum versus Union of India and others, a public interest litigation was filed under Article 32 of the Constitution of India by Vellore Citizen Welfare Forum against the pollution which is being caused by enormous discharge of untreated effluent by the tanneries and other industry in the state of Tamil Nadu. It is stated that the tanneries are discharging untreated effluent into agricultural field, to roadside, etc. The untreated effluent is finally discharged in river Palar, which is the main source of water supply to the resident of the area. In this case, the court, on the basis of precautionary principle and polluter pay principle, decided that consent has to be taken from the board to run the tanneries, and if the consent will not be taken, tanneries has to close down the business activity. One interesting feature of this case is that in this case the Supreme Court has not banned the tanneries in toto. They put a restriction that the consent has to be taken, and those industries which will not take the consent, that they have to close down their business activities. In Indian Council for Enviro Legal versus Union of India and others, etc., environmental organization brings to light the problem of people living in the vicinity of chemical industrial plants in India. The real calamity occurred in this village when Silver Chemical, a sister concern of Hindustan Zinc Limited, commenced production of H-acid in a plant located within the same complex. H-acid was meant for export exclusively and has already banned in various developed countries. Its manufacture gave rise to enormous quantity of highly toxic effluent, in particular iron-based and gypsum-based sludge, which if not properly treated pose grave threat to Mother Earth. It can poison the earth, the water and everything that comes in connection with it. In this case, it was directed to the central government that the central government shall consider whether it would not be appropriate in the light of the experience gained that chemical industries are treated as a category apart, since the chemical industry are the main culprit in the matter of polluting the environment. There is every need for scrutinizing their establishment and functioning more rigorously, and it is also directed that no distinction should be made in this behalf as between a large-scale industry and a small-scale industry, or for that matter between a large-scale industry or a medium-scale industry. All chemical industry, whether big or small, should be allowed to be established only after taking into consideration all the environmental aspects, and their functioning should be monitored closely to ensure that they do not pollute the environment around them. With this, now we will end this session by concluding that no doubt development is the need of the hour, thus the chemical waste. That is outcome of the dollar-friendly approach will persist. The important question is to ponder how much the society can tolerate in the cost of health hazards. The delicate balance got disturbed many a time despite the national and international convention, guidelines and law, the effort of the judiciary and the NGOs. With the power exercised by NGT in many cases, now it is hoped that situation will change soon, but still there are miles to go to ensure the dignified and healthy existence to all the citizens of India. With this, wish you all the best for your exams, and if there is any query regarding this module, please feel free to write over the online portal that is available. Thank you.